Hello and welcome to the second season of the No Bullshit Property Podcast, brought to you by Cert Property.
I'm Howard.
And I'm Paul, and today we'll be talking to Matt Spilsbury from CBRE to discuss the role and importance of viability in the built environment.
Before we get started with this episode, just a quick reminder to check out our previous episodes to give you an insight into our approach to transformative property management in the ever-growing build-to-rent sector and how we're building the sustainable communities of the future. So, thanks for joining us today, Matt. We like to start off talking about a bit of market news, and I think this month the market news is very relevant to the topic at hand in terms of planning and the proposed planning reforms that the Labour government have talked about. We've had the King's speech, which has further kind of doubled down on the reintroduction of housing targets, but given away kind of very little other than that. We'll get under the bonnet of what your thoughts are on planning reforms and all that a bit later, but reintroduction of the housing targets, thoughts on that?
It's essential, isn't it? I think it's been, unfortunately, it was important before to make local authorities deliver against the targets. I think you took it away, and actually we started to see local authorities renege on some of those responsibilities. Obviously, massive increase in housing needs. It's not going away, putting more pressure on affordability. So bringing it back in, really important. Mm-hmm. Make local authorities deliver on their requirements.
Yeah, absolutely. And the other big piece of news in market news is they
want to push through the Renters Reform Bill and
absolutely.
The abolishment of Section 21. So we've talked about that for a very, very long time. The last government failed to get it through, but it seems to be back on the agenda as a priority.
Indeed. And an introduction of what they've called, I think it was Awab's law, in terms of enforcing landlords to make repairs of things like mould or anything like that in fixed timescales. So some important reforms there coming out, and we've talked in previous episodes about the Renters Reform Bill and potential impacts of that. Thoughts on that, the reintroduction of that and the Section 21 removal?
I think it's a good thing for tenants. It regulates the industry. I think it brings it up to a standard, an acceptable standard. And I think it's interesting when we've talked a lot about build-to-rents in the cities, but this regulates the whole industry and brings it to standard outside those places, because there's such a disparity in the levels of rented accommodation. So we do welcome it. Yes, for landlords, it's going to make things. They're going to be forced to do things in the right timescales, but they're going to be. That's in providing the best sort of rented accommodation. Yeah. So I think we welcome it. The Section 21 will mean that you can't do any no-fault evictions, but again, it's standardising the industry and making sure we're delivering on good service. And as I say, bringing it in line with the cities and the standard that it is.
Absolutely. Okay, well, moving on from the market news then, let's talk planning and more specifically the role of viability within planning. So I think, great way to start would just be to tell us a bit about yourself, Matt, and your background and your role at CBRE.
Sure, will do. Well, thanks for having me, first of all, chaps,
Pleasure.
And on a rare sunny day as well in the city, and a great backdrop as well to be sat doing this. So appreciate the invitation. So a little bit about myself. So I'm Matt Spilsbury, Senior Director at CBRE. I'm based up in our Manchester office in the north, but covering the northern regions. Predominantly based here in the northwest, but also cover Birmingham, Midlands and South, and then across into the southeast as well. So a fairly national remit, but with a core of being here in the city in Manchester. In terms of what I do, so I'm a planning and development surveyor, but also moonlighting as a town planner. So I have got MRTPI after my name. I have got my letters, but I predominantly spend most of my time doing planning and development surveying activities. I actually manage and lead a team of, there's a range of specialisms in the team. So we've got planning consultants who are sort of regeneration, place-based regeneration focus, so town centres in particular. And they're specialists in putting strategies together for helping draw in investment and then deliver within town centres, setting up public-private partnerships and similar, and then also moving right through to packaging up sites and surplus assets and disposing of those with either independently or with our colleagues. And then we also do a lot of planning viability type work, which is obviously some of the key areas that one of the key areas we're going to touch on today. So that typically means that we're working with clients, whether that's private sector, such as CERT or others, and developers, or public sector, so local authorities or combined authorities. And what we will do is at planning stage, we provide financial analysis in the form of viability assessment and advice to our clients, particularly in the form of planning obligations. So Section 106 planning obligations, affordable housing, typically those things that might be construed as public benefits, which have now, through sort of successive governments and increasingly been placed by central government as a cost on development and a cost on land. So we provide advice as to, well, what can schemes afford? How could schemes potentially be adjusted, or in terms of scale, mass and uses, to try and maximise that? And then we may review that type of work as well for local authorities. So there's an awful lot of work involved in doing that. And it's quite a contentious process. There's a lot of negotiation. But then there's also politics, of course, that comes into it, engagement with local authorities and the views of local members. So it's quite diverse in that sense.
Yeah. I mean, for obviously the topic of planning, as we just said, very, very relevant. Given, a huge part of the Labour manifesto was planning reform. We just said there's some initial announcements about it, but for me, we've gone through a number of planning applications over the recent years, and when looking at planning reform, I think viability is a bit of the planning process that's probably least understood, but has become such a significant part of the process, both in terms of time that it takes to deal with that. Like you said, a lot of work goes into it, but also not just the time, but determining whether an application is successful and supported or otherwise. So how has viability kind of come to this point within planning to sort of be of such significance?
Yeah, I think it's because of the role that it plays in determining the level of public benefits or social benefits that a development scheme can provide. It's the history of it is effectively driven from shifts successively in government of delivering infrastructure, whether that's social infrastructure or physical infrastructure within new settlements or urban areas, and then also affordable housing. So from something that the public sector funds primarily to something which land and development is seen as funding. So you could look at it in one way as a sort of a form of taxation delivered through the planning system rather than delivered through a formal taxation process. So because of that, because it's not a formal taxation process, it's a sort of negotiated process, and there's targets set in place which are those that, for example, not every scheme can meet. So a local authority will set in place aspirational but supposedly deliverable targets on these social benefits, and they all effectively act as a cost on a development scheme, so they have to be considered in that sort of capital stack when you're looking at appraising whether a scheme is viable and what it can deliver on a site. Not all schemes can deliver against those, and as a result we end up in a process of discussion and debate where evidence needs to be put forward by one side as to whether they can deliver let's call it the applicant, as to whether they can deliver the targets that the council, local authorities put in place, and the developer, where they will say, well, actually, this is what we can afford, and the local authority will usually independently review that and determine whether that's appropriate or not. There's then a negotiated process looking at the evidence, testing that, and assuming that the parties can objectively come to some form of agreement. That then is put to officers, and officers ultimately have to make a decision around whether to grant planning, and one of those policy tests is, of course, affordable housing and Section 106 planning obligations. So it's one of those sort of critical measures that a officer has to weigh up in the planning balance as to whether to grant or recommend a permission is granted or not. You ultimately then, of course, have to go on major schemes, typically before elected members, so councillors on a planning committee, and they have they're there effectively to represent the electorate. They will see the evidence and what's been put forward by the planning officer, but ultimately they are the ones that make a decision, and their decision may be motivated in a different way. There may be other concerns that they have. They may look at this in one way or another, and they may not always support the officer's recommendation. They may consider something different. They may, in some instances, not have a full understanding of the viability process, which may lead them to a decision where they look at the black and white of what's in a planning policy and see a set of target figures and see a scheme potentially not being able to deliver those in full, which is a particular issue at the moment in the last few years, given challenging market conditions. And they may then turn around and say, well, actually, why is this happening? Mm-hmm. If they're not fully informed or don't fully understand the process, then they may think that there's a situation arising where the policy simply hasn't been supported or delivered upon by the developer, and they might recommend for refusal. So it's become quite contentious because issues around affordable housing and other planning obligations at a time when local authorities are cash-strapped, we're hearing that there's high numbers of people and households waiting for affordable housing. And I think it's become an issue because we end up with a situation where there's potentially a view that if you're not delivering everything that policy is asking for, then you're not delivering on your full public benefits or social value for a scheme where you should be. Mm-hmm. But as we know, that's not always possible because the finances don't always add up.
Yeah. I think something for me that's important in it, and you alluded to there, is obviously we have the overall process for a planning application, and that is ultimately typically determined by a planning committee who have to take into account all the range of factors part of that application. As we just said, viability is a big critical part of those factors. But illuminating for me, we had a recent application where you felt that the planning committee didn't understand necessarily how viability itself works, and just were looking at the benchmark targets and kind of assessing the application against, well, it's not hitting the benchmark affordable targets. So that kind of leads me to think, is the process that it works under right? You said there, both parties kind of submit evidence and then have to negotiate to come to a position, but often that's not possible because one party's view is so different to the others that you can hit an impasse, and there's actually no mechanism within viability itself to kind of resolve that impasse. There's not a viability committee that you then submit both your arguments to and they rule, like a court case, a dispute resolution mechanism.
You could, I mean, it's a valid point, and that's something that a number of commentators have actually suggested. Well, potentially something like a dispute resolution process or an arbitration type process would be useful in those circumstances. And there's not actually anything stopping that happening. It could be something that is called upon. I've not actually had a situation where we've had to do it as yet, but it has been discussed in various cases where an impasse has been reached and no kind of sort of settled negotiated position could be agreed between the parties. And if you look to, for example, Section 106 legal agreements, you'll often find that if there's some form of review mechanism of the viability assessment or clawback type arrangement that's included within those documents, where a scheme, for example, hasn't been able to meet those full policy targets at the planning application stage, and it's testing whether when the scheme's delivered, if it's outperformed, for example, within that, typically there's a reference to a dispute resolution process should the parties not be able to agree on the review mechanism outputs. And so you think, well, actually, if it's included within that, then there's no reason why theoretically that couldn't happen. And occasionally what we've had is where we've had a situation where we may have been asked to act as a third party on behalf of one of the parties to review the work that's been done and to provide some additional advice, but not through necessarily a formal process. So I think it as long as it's something which both parties agree to, that the third party is objective, and that it's binding, and both parties are in recognition that it's a binding process, and enter into that, fully aware of that, and do then deliver on that and follow through with it thereafter, that I don't see a reason why that couldn't happen if all else has failed, really, to stop the issue of this process becoming protracted and unreasonably delaying granted planning permission or affordable housing delivery or general housing delivery. There is obviously the appeal process.
Yes.
But again, that's costly potentially for both the local authority and the applicant or appellant in that process, and time consuming. So appeals lead in, particularly if it's a hearing or an inquiry on a major development, 6 to 12 months, and you may be waiting a little bit longer for the determination from the planning inspectorate. And again, obviously that's a big delay process. The costs have got to be met by somebody. It just means that we're not delivering when we could be. So no, I think it's a good suggestion, and it's one that you look to potentially one of the actions that the new Labour government could deliver. One of the things that they could introduce would be such a process.
Yeah.
And they could actually say, well, we'll set up an independent body, or what do they like to say? They call them things like task forces. Task force. Or what was the last one? They were going to, I can't remember what it was. I might be wrong, but something like a group of planning superheroes.
Task force sounds cool.
in Cambridge. Yeah, that's it. But a group of surveyors, and they did talk about actually pre-election, I think it was Labour. I think they did talk about, it might have been Matthew Pennycook in his role as shadow housing minister at that point. I think he said that they were considering introducing a specialist group of development surveyors with a viability specialism to support local authorities where they didn't necessarily have the skills or the capability to try and accelerate some of those decisions. So actually, we're on a theme here that Labour may have been talking about already. I would say my view of that is, well, it shouldn't just be to support local authorities. Actually, it'd be better if it was an independent process. So if a time period had been expended or it had been agreed that neither party could reach an agreement, then we'd go, right, well, we'll call on this central outfit of viability superheroes or whatever they might be to come and make a decision. And that should stop development getting stalled or, for example, schemes being unreasonably refused on that ground.
Yeah. I mean, you mentioned they're unreasonably refused. Obviously, we've been through a period where viability has been incredibly challenging from the macroeconomic shocks that the country's faced, the world has faced, construction inflation, interest rate rises. Do you think there's, because obviously you said before you sort of work on both sides, local authorities and developers, do you think there's quite a lot of distrust in the process in terms of the figures submitted?
Yeah, it's a good question. In some cases, I think there is. I think some of it stems from historically there being a sort of a looser set of regulation, if you want to call it, it's professional standards, guidance that was used as the viability process was emerging, because obviously it emerged, as we said, in response to a shift in national policy and an expectation of investment moving in, or for some of these public benefits moving to the private sector and almost being used to capture value created through the granted planning permission, saying some of that should go back to a public benefit. So as it was emerging, there was probably less guidance around and it was less stringent in how it was undertaken. And I think there were probably multiple outfits undertaking the work that weren't necessarily doing it in a way that was standardised and adhered to, as we'd expect, the principles of the Royal Institute Chartered Surveyors. And unfortunately, that's taken, I think, quite a lot of time to work its way out of the system. And there's still myths and disbeliefs about it now. But actually, it's far more tightly managed and regulated than it was. So we've got national planning practice guidance now, which is quite detailed around viability. And historically, I input into that. Then there's the Royal Institute of Chartered Surveyors. They have a strict set of professional standards that, as chartered surveyors, we have to adhere to, and then there's also professional guidance as well within this remit, which ties back in as well to various forms of Red Book valuation. Not all of it, but it does. So there's some really strong, there's a really strong framework around it, which does require standards to be adhered to. And obviously, if they're not, then those can be tested. And if you're found wanting, then there's obviously the process that the ICS will take you on in that respect. So I think what it's meant is that actually there's a smaller pool of professionals probably advising in this space than there was historically. And it successively governments have shifted, I would say, it was potentially looked at historically that the process more favoured the developer and the landowner. I think that shifted quite significantly in probably the last 4 or 5 years through successive changes and more recent policy and standards, to be quite frank. So my view is there's still some mistrust, but actually it's more tightly controlled, undertaken more by professionals who are qualified and have got significant experience. It's all in the public domain now as well, which is important. So viability assessments are published, and they should be. So the National Planning Policy Framework requires publication of all the documents, both for for any party that's involved in that planning process. And I think that's made a big difference because previously there was sort of accusations of smoke and mirrors and it's being a dark art. But a lot of that was because a lot of the information wasn't published in the public domain. So you went back to maybe even sort of 4 or 5 years ago, and this document, the documentation, you would just see one line that said something about how much affordable housing or the implications of viability on a scheme, and I think that led to some serious mistrust amongst the public, particularly amongst councillors and officers who may not be trained as development surveyors or practice in development. Or might not even be qualified town planners. And even if they are town planners, there's not necessarily an expectation they understand, development surveying. So I think there was a bit of a mistrust because of that, and then a lack of understanding. And increasingly, it's been sort of brought into the light, more tightly controlled, and I feel that that's made quite a big difference. And I think it will take quite a long time for that sort of mistrust to probably dissipate. But the more it is in the public domain, the more it's discussed. And I think the more the officers and members have to deal with it and help and understand it, the more it should be seen as something which is actually helpful to the process, and does hold developers to account, and local authorities as well. They have to review the work and they have to do it in the same way. So I think one issue that probably it slightly goes back to a point that you made earlier, but one of the areas of mistrust potentially is about training, member training, officer training. So where we work for local authorities, actually a good example in the Midlands, we were asked by the officers to come and do a briefing. So we did an hour technical briefing to members on the planning committee who just joined about the viability process, about Section 106 planning obligations, about the local plan and policies, and how actually those are targets and how individual schemes then have to be tested against it at the application stage. And we gave them some case study examples that were live or recent examples within their local authority area. So it was on their patch, they knew it. And we had really positive feedback that members found it really useful. So something like that, I think, would be valuable if it could be rolled out more widely.
Yeah, I mean that absolutely. Understanding is a key element of it, and actually was why I raised the question about lack of trust. It was born out of a comment that was made to me previously, where I'd actually been questioned to say, well, why are you submitting this planning application if your submission for viability shows that the scheme isn't viable? And, obviously, if it's not viable, you can still submit a planning application and hope that the market is going to move in your favour and makes the scheme viable. But, just understanding, I guess, something as simplistic as that just shows a bit of a need for a greater level of understanding from all parties in terms of the role of the viability process. And obviously, the situation I explained there, if things do improve and the market does improve and the scheme becomes viable, typically these days we will see a late stage viability review that would capture that anyway. So it's not like, you're trying to submit something to pull wool over someone's eyes and then go, aha, I actually did all right out of this. So yeah, I think understanding is a key way of kind of rebuilding trust, whether it's planning committee, whether it's developers, whether it's officers, whoever. As I say, I think that's really important to improve everyone's knowledge on it.
I'd agree. I think it was the process of viability, as we said, was born out of the increasing shift to the private sector and onto land to try and provide public benefit. But equally, it's there because at the application stage is a knowledge that market conditions fluctuate and change. As you talked about, we've seen lots of different factors. COVID, in particular, it's been a very challenging 4 or 5 years with COVID and the disruption that's caused, rapid inflation, costs spiraling, cost of debt increasing, mortgage constraints. It's a huge, huge culmination of factors that have actually made it quite difficult. And viability is there to provide flexibility to development at the application stage to try and help delivery still happen, but with a recognition on some of the larger schemes or schemes that might take a while to get out of the ground that, well, if it does outperform and the developer has done a really good job and actually turned something which is marginal or unviable at the planning stage into something they could actually get out of the ground and deliver and people can live in or work in, then ultimately there's an opportunity for the local authority to essentially sort of claw back some of those public benefits. And typically that's sort of shared between the parties up to a policy compliant level. So those targets still can get hit if a scheme successfully gets delivered. So I think it is important that is understood. And I think the use of review mechanisms is going to be something which I expect we see increasingly. Simply because it gives that second, let's call it bite of the cherry, and it will mean that local authorities in what are a more challenging set of economic circumstances, which to be frank, not everybody is acknowledged, but a more challenging set of economic circumstances can still support development occurring. They can still support housing targets being met, and economic development coming forward. For jobs, provision of jobs and such forth as well. It's so important. And we've seen this Labour government obviously come out saying we want to be an entrepreneurial government, we want to support value creation, wealth creation, deliver 1.5 million homes. And I think actually that being instilled at a local level is really important, because if decisions around development are deferred or refused, then all that does is just make that increasingly challenging. So if we can help educate local authorities, members, the public, that actually this process is helping to deliver schemes, and like you said, we're not trying to pull the wool over anyone's eyes, we're trying to get things delivered. And if there is an upside to it, then it could be shared. Then I think everybody benefits.
Yeah, indeed. Something we've advocated for is the timing of when the actual assessment comes in. So as we just talked about there, currently it's part of the application process and it's dealt with before the application's determined. Is a better approach making it a precondition to start on site, so the assessment is actually run at the point in time that the scheme is likely to be delivered. It removes it as a potential delay in terms of the application process, so that can move forwards quicker. And it's actually testing the inputs at the point in time when they're most relevant.
Yeah, it's a good suggestion. I think I wouldn't see a problem with that. And I think that's a logical time to do it. So almost what we would call that is an early stage review, as in the current context of what happens now, where you typically have an application stage assessment, and then potentially, and depending on the local authority you're in and their policies, an early stage review. And you may also have a late stage towards the back end of the development programme or beyond it. So that would be sort of shifting the viability decision, an issue, from something which is happening at the planning application stage to something that happens beyond that. So I would say I don't have an issue with that. It would mean that in terms of, for example, funding, there would have to be some sort of careful consideration as to how that worked in the acquisition of land, for example, and the contractual requirements to potentially draw down on land at the point of a planning permissions crystallised, because at that point you still wouldn't necessarily know what your obligations were.
Very true.
But I'm sure that could be worked out. And then you would be looking at it when there was not necessarily a clear crystallisation of value on everything, but certainly a crystallisation of costs, because you expect you might well have your build contract in place at that point. There's still risk, of course. Mm-hmm. Obviously, we saw through COVID massive delays, cost escalations, all sorts. And now we've got things like gateway tests and Building Safety Act that are causing delays as well to delivery and sign off of buildings too. So there's a range of factors that are still unknown, but it would mean that it would be something which wouldn't necessarily delay development in the planning process. You could ask, are you just kicking the can down the road though? But if it helps get schemes secure planning permission and increase the certainty around delivery, then actually maybe that's a positive thing. And equally at that stage, what you might well do is depoliticize it. So instead of it being a matter where, like you say, there's a lack of understanding between parties, such as members at the moment, or officers or the public, it's something which is actually a more defined numerical process, and actually it sits, like you say, with the outcome being, well, what are the numbers, and how can we reach an agreement on what those numbers are, and if we can't, well, is there a dispute resolution process that we go down to finalise that? I think it's a good suggestion. Should definitely be explored.
Should have run for the government, shouldn't I?
I might steal that policy. I'll steal that idea. Unfortunately, it's on video now that you've said it, so I think I'm going to have to give you that one. I can't claim anything.
Any other suggestions then? Can't claim that one.
That was what I was going to say.
I mean, I think for me, the viability process obviously is an important part. We talked there about a couple of potential tweaks to it that might make it flow smoother or be more fit for purpose to achieve what it intends to achieve. Any other thoughts on that vein that you've had?
I have. Well, interestingly, the point that we talked around review mechanisms and the rollout of review mechanisms is something that I'm on an RICS working group that previously we engaged with the previous government and shadow government, as it were, and I think we'll be continuing to engage with the new government. And one of the recommendations that we made was reconsideration of things like viability review mechanisms, for example, member training. The view that we have collectively as the RICS is actually that the process is relatively fit for purpose with some refinements to it. There could be, I don't want to get too technical, but there could be refinements to some of the technical methodology that helps to make it clearer for both the industry and for local authorities.
Go on, give us a technical example.
I was worried you were going to say that. So I would say that there's a concept called benchmark land value, which is the simplest way of explaining it is that it's a construct which should look at the minimum reasonable price or expectation of price that a landowner should have in releasing their land for development. And it differs from market value. It differs from the current use value quite frequently. But it's typically an assessment of what is the current use value or existing use value of a site plus a premium. And that premium is typically to compensate the landowner for releasing the development site. They may have costs in doing so, or they may be forgoing future earnings, for example. And therefore there is typically a premium. It's not usually a significant premium on brownfield land, can be more significant on greenfield. And one of the concepts that I discussed with the previous government, this was going back quite a while when planning practice guidance on viability was introduced, was about whether we could be more clear around what those benchmark land values should be, linked to potential locations or typologies of development or typologies of existing land use, to try and make it less of a negotiated point, and something which there was more certainty for both parties, and try and be one of those things that doesn't get to a dispute around a disagreed point. It wasn't something at the time that was taken on, but I still feel that that's something that could be looked at again by the new government in a way that helps remove some uncertainty from the process and provide more guidance. They could do the same around, for example, target profit margins that are deemed reasonable. They have to be enough to secure funding and ensure that development is deliverable and fundable, and to justify actually undertaking development rather than capital being deployed in something else. But providing some more clarity around that could be helpful as well. So a couple of technical areas where they could provide a bit more guidance or elaborate on existing guidance, rather than it doesn't have to be policy or legislation, for example, but there's more that can be done at a fairly technical level to help firm up the process and streamline it, to be quite honest.
Yeah, good suggestion. Yeah, I think the benchmark land value point, that resonates with me. Obviously, having been through the process, and I think the challenges most often arise where the elements are most abstract, and the benchmark land value is one of the more abstract elements in the viability inputs. So yeah, you've got that one on record. So very good. Paul, obviously viability is all completely new to you.
Yeah,
so...
I mean, I've been very vocal through this. I think as always when we talk about planning, I mean, it is all new to me, and it's not something I am exposed to on a day-to-day basis. So it just goes again to consolidate the fact that there's so much detail in it and so many different plates to spin
at every stage of development.
I was actually thinking all the way through as you were speaking, how do you sum it up in really simplistic terms, the word viability, but actually there's so many things that are involved in it. It is quite difficult. So I think thank you, because it's been an education for me.
And that's, I think, it comes back to the crux of the conversation you were having is, members of a planning committee or the layperson on the street looking from the outside in are seeing planning permissions being granted with very little understanding of something as important as this, which is determining whether they're deemed acceptable or not. So
I think what's interesting is it seems like there's a real commitment to, as you say, making it more transparent and regulated across the board, which is interesting, and helping people understand exactly what you've just said. I mean, welcome those changes and some of those that you've suggested. So I'm sure the next time we talk about it, I'll learn a little bit more.
It'd be interesting to see where the government goes, because there's things they could do to actually assist. So just a couple of examples of issues that have already been raised, I think, with government, but by CBRE and others as well. For example, things like at the moment, the government has what's called an affordable homes programme, which is effectively monies distributed as grants to support delivery of affordable homes through Homes England, their housing body. And that money typically goes out to registered providers, and it helps them fund delivery of new affordable housing. But you can't at the moment use that in conjunction with Section 106 affordable housing. So we often end up in situations where we would benefit a scheme that has a viability gap by closing that gap using Affordable Homes Programme grant and being able to deliver some affordable housing. But we can't do it through the process, through planning with the Section 106 agreement. And that leads to some confusion and mistrust from local authorities in some cases, where we're sort of saying, look, we can't deliver it through 106. But actually, if you let us try and deliver it in some way and support a planning application with no Section 106 affordable housing, we can actually bring a partner in who is able to use their status and grant funding to be able to deliver affordable housing. And that educating local authorities around that at the moment has been a challenge. And I think it's something which, if we can't get that resolved through the current system, then sort of reforming that affordable homes programme to allow some of those monies to be utilised on Section 106 affordable housing would be really important, and help schemes get delivered. Other things is probably looking at the moment, you mentioned about sites being unviable at the planning stage. So a lot of what my team works on is putting together business cases and financial cases to secure public sector funding. So, for example, on high density development where there's a lot of viability gaps that need closing. So examples typically are the brownfield land funding, for example, which is held by the combined authorities, so Greater Manchester or West Yorkshire. I'm pointing in that direction, like Yorkshire's over there. I think it broadly is. Is it? Okay, good. Right, I'm fairly accurate in my geography then, which means that Birmingham's over that way somewhere, and so that would be the West Midlands. So the combined authorities have been given pots of money that they have to deliver in a finite time, and there's a lot of different developers all vying for this public sector funding. Grant money, some of which is repayable, but not always. And it's very competitive and it fluctuates, and where we're successful in doing that, it can help plug those viability gaps we've been talking about. But unfortunately, the nature of that is it means there's a finite pot and it's on a scheme by scheme basis.
Yeah.
So one of the things that we're considering is, well, actually, could the government look at this in a different way? Could they use some sort of place-based funding through public-private partnerships, leveraging their own investment essentially, to bring in additional funding from, say, institutional funds, for example, and look at this on a wider scale, and look at actually, well, could we do some sort of impact fund which looks at local authority assets or a mixture, and instead of it being this kind of individual site-by-site funding, grant funding process, looks at something which might enable significant amount of development to come forward in regeneration areas, urban areas, and then potentially with best sort of value cost ratio, benefit cost ratios, and potentially return some money back to the public purse, rather than the sort of a hodgepodge of funding that they've got at the moment.
Yeah, which seems disingenuous anyway, because as you said before, looking at the viability process, the proceeds are effectively a revenue or a tax for local authorities. But if that's being imposed and then you're basically funding that through grant funding, you've kind of equalised it out, which, like I say, seems a bit disingenuous. It's robbing Peter to pay Paul.
Sort of circular, isn't it, in some way?
Yeah.
So kind of getting away from that. I mean, it's played a massive role in helping schemes come forward over the past few years. There's either through supporting public sector finance, for example, at lower borrowing rates, which obviously is repaid, or through grant funding. That's kept in a lot of the circumstances, cranes in the sky, like we can see around us on the skyline, through difficult market conditions. But going forward, it's perhaps time for a sort of a different conversation and a bit more of a strategic view on how we can help deliver development in high density, high cost type locations and regeneration areas as well.
Mm-hmm. Let's save more on that for a future episode. There's a whole other topic in there. But appreciate your time today. Really insightful, and hopefully unpicks a few of the...
It must be a real buzz when one of these goes through. That's right.
I mean, there's a lot of work that goes in, so it's all part of the process though, isn't it?
Thank you very much for having me. It's been an absolute pleasure.
Thank you. Just a quick reminder to check out our previous episodes episodes to give you an insight into our approach to transformative property management in the ever-growing build-to-rent sector and how we're building the sustainable communities of the future.